I'd like a little guidance from the court. Pending before the court today is the big enchilada, the petition for surcharge, but there's also the two accountings for the guardianship, the accounting for the trust, my attorney's fees itself, the release of the additional $22,500 that was agreed to be paid to Mr. Hilligas's wife. That's Debbie Hilligis. I think I got everything there.
Well,
so
first, I apologize for interrupting, Mr. Torvinen, but as to any outstanding accountings, the outstanding accountings were lodged long ago. There has been no objection or traverse filed related to those accountings, and I'll simply sua sponte approve the outstanding guardianship accountings and the trust accountings, making easy, if you will, the math related to those accountings and the argument around retaxing of costs, etc.
Okay. That being said, I'd like to know if you could inquire of Mr. Evenson if there's any objection to the payment of my proposed attorney's fees as amended by me just a moment ago.
Mr. Evenson?
Your Honor, I have a number of issues and objections to raise. I was waiting for the opening statement to do that. I would prefer to do it that way rather than piecemeal. If Mr. Torvinen is finished, I can move on, but I'll return the floor to him through you if that's okay.
That's okay. You know, Your Honor, I'll reserve, if I could, my opening statement to the end, and so I can get an idea, and probably the court would like that too, about the issues that Mr. Evenson plans to raise here today.
Yes. Mr. Evenson has indicated a desire to make an opening statement. I'll give him an opportunity to do that after you rest your case, Mr. Torvinen. I don't know if you also want to offer an opening statement or not, Mr. Torvinen.
I'm confused, Your Honor. Said after I rest my case, he'd make his opening statement?
That's correct.
You mean after you mean put on all the evidence?
Yes.
Your Honor, would you reconsider that? I'm just trying to figure out where they're going with this.
All right, let me ask.
It's confusing to me, I'm sorry.
That's okay, I understand. Let me ask the question this way. Have you and Mr. Evenson spoken at all about this case?
Yeah, yes, we have. We spoke last night, and we were actually, we had some dialogue on the basis for settling it, but we didn't quite get there. We didn't get there. And we spoke about some issues, but we didn't have a specific conversation about what his objections were or what he planned to do on behalf of Mr. Hilligis.
All right. In my effort to get us to the heart of things, I had indicated that I would ask Mr. Evenson to make his opening statement after Mr. Torvinen presented his case. Inasmuch as Mr. Evenson has come into the case late, that's not a criticism of you, Mr. Evenson, it's just an observation. And inasmuch as counsel did not speak about the case until last night, it would appear that knowing the range of issues will be of use both to the court and the parties. Again, I ask, Mr. Torvinen, do you intend to make an opening statement?
No, Your Honor, I'm going to waive. We're short of time.
All right. Mr. Evenson, would you like to make some opening comments?
Your Honor, I would, and I would just note that Mr. Torvinen and I have spoken several times since I was retained late last week. As always, Mr. Torvinen is a professional and very easy to deal with. We were supposed to talk. He was supposed to call me back last night after we spoke last, and that did not occur. So I figured that there was no further settlement. In any event, Judge, with regards to this case, which of course you've already observed I am an extreme newcomer at, and has been going on for a number of years, I have to admit that I am perplexed and somewhat flummoxed by the procedural posture of this case. And I have made many notes in a short period of time, and to some extent they're somewhat disjointed. But relative to the issues that are before the court today, I would note that there are a number of issues with regards to surcharging Mr. Hilligis. First of all, it is not specifically allowed by Nevada statute. Second of all, most of that surcharge relates to an order of attorney's fees relating to things that took place during the guardianship or many years ago during the guardianship. I would note that under the applicable NRS for the guardianship, which is NRS 159.345 and 159.346, there is a specific statutory limit as to what can be recovered from my client in that circumstance. Additionally, I think that there is an interesting issue there, depending on when those issues were ordered and when those things took place, as to various limitations allowed for under the law in terms of collecting attorney's fees. I don't want to say it's a statutory statute of limitations argument, but the case history in Nevada as it relates to attorney's fees does put some time frames on when things to be moved and need to be ordered. And it does not appear as if any of those were followed here. Moreover, Judge, as the court is well aware, under 159.171, if I wrote that number down right, but I think that's the correct number, the guardianship is terminated upon the death of the protected person. And that is actually referenced at 2 points in those Nevada revised statutes. So the guardianship proceeding actually and technically ended on October 16th of 2019. And there is, I don't believe under the statutes, a technical guardianship proceeding still in place unless it relates to the administration of the trust. But the actual guardianship itself over the protected person expired, for lack of a better way of putting it, when Susan expired on October 16th of 19. And Judge, it does say in the statutes that the court can assume a trust jurisdiction, and it does not say what happens after that relative to the administration of the guardianship and all of those other things. So turning from the multiple issues that appear to be present in surcharging my client for issues that took place during the guardianship many years ago, or 3 years ago, because the guardianship no longer exists and there's a statutory limit on what can be done to him, then you turn to NRS 164 and items number 25 and 26 in Mr. Torvinen's motion. There is no statutory limitation, as Mr. Levine notices, relative to the equitable powers of the court in the trust case. Now, the case that he cites for that, Klobaka, was not properly cited. It is an unpublished opinion. It was not a published opinion. It is after 2016, so this court can hear it. But when he cites a unpublished opinion, Mr. Torvinen is under an obligation to supply, to inform the court in the pleading, it's an unpublished opinion, to indicate that unless I could be mistaken on that. I did not look up a slip opinion, but I did not see anything in the opinion that indicated it was a published opinion as an advance notice or anything like that. And so it may be unpublished, and he's supposed to send a copy and everything else. Klobaka is primarily based upon Pizarro, and Pizarro is a case in Nevada that is published, but it is litigation about a trust in the context of a divorce. And in that divorce, the two married folks separated their community asset into two separate properties, spendthrift trusts, and then got divorced. And that case is all about the district court in Las Vegas's allocation of things within that trust. It did not mention the term surcharge that I saw in there, and it did not and the trust in that case with regards to attorney's fees on a specific motion or issue, it was not a general, and for lack of a better way of putting it, Judge, and I've read the file here, and I've read your rulings to an extent, and I've read Judge Doherty's rulings to an extent. I have yet, neither in Pizarro or in any other case cited, is there a provision that says the court has made a finding that a beneficiary of the trust or a party to the guardianship is so odious and has litigated in such a way that everything that they did has to be considered and a surcharge be done. In fact, in both Pizarro and in the California case cited by Mr. Torvinen, that case, which I have here, sorry, I printed it out actually, which is Pizarro. Sorry, Pizarro is the California case. In that case, Judge, that was specifically related to a specific motion that was brought. And the underlying law on that Pizarro cites, those cases were also based upon a specific motion that was brought, and then attorney's fees were awarded on the basis of a specific motion. It would appear from the way that those cases are decided and the way that those are written, that the motion for attorney's fees relative to the actions undertaken by Mr. Hilligis, for which Mr. Torvinen now seeks on behalf of Ms. Renwick and the estate to surcharge my client, it would appear should have been done in a piecemeal manner after each one of those, or at the time each finding was made, rather than doing it as a general at the end. And there is, and when you start relying on the court's inherent powers of equity, those powers that are cited in Pizarro seem to discuss very specifically the ability to award attorney's fees on a specific issue. Nothing that says that a finding of vexation litigant or of anything like that requires a surcharge. In fact, and I can't say that I read every line of every case and can state this with certainty, but the word surcharge did not jump out at me at any point in any of the cases that I read today. And so the terminology of surcharge that is being used by Mr. Torvinen is not found in the language of the cases that he cited. As he candidly admits, it's not allowed under Nevada's statutory scheme, and it is not found within the cases that he cites relative to the equitable powers of the court. So we have serious concerns about the jurisdiction and ability of this court under the statutes and under the guardianship laws to even consider this motion as it is currently put before the court. Then, Your Honor, I moved, in the limited amount of time I have, I moved another layer down in this unpeeling of the onions. And most of these fees, in fact, you could argue that apparently all of them, now that we're down to the 81,000 and change, and the amount that the fiduciary has withdrawn, which is zero, which is not attorney's fees, but then the 1,500 that Ms. Christensen took off, it appears as if obviously the vast majority of it is attorney's fees. And now, of course, we're at zero due to the on other fees. So it's all attorney's fees now. Well, attorney's fees in Nevada are governed by statute. And the court is well aware that Nevada case law has stated very specifically that absent a statute or a specific order or a specific agreement or anything else, attorney's fees are not to be awarded. And then you start going through 18.010, NRCP 68, all of these kind of things. And none of that has been done here. The motion from Mr. Torvinen relative to his attorney's fees in this case does not comply with the Brunzell requirement, does not comply, is not in the form of an affidavit, and is not in the form of Brunzell. That would seem to be required by law. And so it seems to me that there is very shaky legal ground that this court is being asked to consider awarding these fees, very shaky factual basis for it as well. I am not in a position, nor am I going to argue before this court in any way, shape, or form that my client, the findings that were previously made by the courts or the findings that are in existence that were not appealed and have never been dealt with to this point are wrong or inappropriate. I don't think I can legally argue that, and I don't think I would keep credibility with this court if I did such a thing. And I don't put on those kind of shows for clients. But I do think that the underlying statutory basis, as admitted by Mr. Torvinen in lines 25 and 26 of his motion for surcharge, make it 100% clear that the statutory scheme here and the basis upon which we are proceeding is highly dubious. And I think that these issues need to be ferreted out appropriately in appropriate motions and heard by this court before we spend hours hearing testimony. I think Mr. Torvinen should have an opportunity to comply with Brunzell. I think he should have an opportunity to state under what statute he's proceeding under relative to attorney's fees. I think that the issue of equitable surcharges, which have never been found in my reading in California law that's been cited or in Nevada, needs to be strongly considered. And here's why, Judge. I think the appellate argument becomes apparent to this court when it thinks about what is being asked for here. What is being asked for here is not that that my client actually pay those fees. In the schedule from Mr. Torvinen, he is paid off the top, Ms. Christensen is paid off the top, and then the amount that is left is 150. Well, then that is given to whom? His client. Well, that's a penalty provision. That is punishing my client by taking property that he is legally entitled to out of his pocket and giving it to the other party. It's not even being used to pay the attorney's fees. It's not even being used to pay anybody like that. It's being used to enrich Mr. Torvinen's client after all of his money is taken off of the top. In my opinion, Judge, that is a particularly, and I've used this word already today, odious interpretation of what a surcharge should be and what would be allowed here. It is not fair to seize the property that my client is duly entitled to under the terms of the trust and penalize him in a way that is extra statutory and appears to be extra common law, and then take those exact same fee, that exact same money, and put it into the pocket of Ms. Renwick. I don't believe in any way, shape, or form that that decision would be upheld on appeal. I do not believe it's ever been seen in Nevada, and I don't believe it's ever been seen in the California cases cited by Mr. Torvinen. So my opening statement is, Judge, is that there is an extreme lack of legal and factual ability on which to proceed today, and we need to move forward and get this estate and this trust closed in a much more productive manner than by breeding more litigation from whatever this court reaches today. Thank you.
You're welcome, Mr. Evenson. Mr. Spitzer, do you desire to make any opening statements or on behalf of your client?
No, thank you, Your Honor.
All right. Well, as to the jurisdiction, I decline to consider arguments not previously tendered to the court, save and except jurisdiction. Here's more particularly why I say that. Mr. Evenson, I know you're new to this litigation, but my prior orders related to this hearing clearly indicated that if your client intended to offer legal authorities or factual assertions at this hearing, he was required to give notice in advance of the hearing of both those legal assertions and any factual assertions, and he did not do so. The motion for attorney's fees, the application for fees in the trust case, as it is styled, was lodged in August of 2020. There has been no production whatsoever by Mr. Hiligas of any legal points and authorities or factual assertions in contravention to that request for relief since then. And to any degree that it's legally available to do so, Mr. Hiligas has waived those arguments. He sat on his hands and filed nothing with the court, much to my surprise. But inasmuch as there's been an assertion that there is no jurisdiction to act, I briefly but directly respond in this way. First, NRS 159.13 is entitled Winding Up Affairs. And while it acknowledges that guardianship over the person and estate, as it were, terminate upon the death of the protected person, it provides clear and specific statutory authority for the guardianship of the estate to continue for purposes of the final accounting that must be filed with the court and to carry on the business of the former protected person. There is a guardianship over the estate of Ms. Hilligis, the decedent Ms. Hilligis. There is her trust, which is within the jurisdiction of the court, as you acknowledged, Mr. Evenson, there is authority to do. And this is a part of winding up the affairs of the estate. So there is both subject matter and personal jurisdiction over the former guardian, Mr. Hilligis, who failed to file a wind-up accounting in the guardianship of the estate. It has been outstanding now for several years. And there is subject matter jurisdiction specifically by statute. So notwithstanding that, unfortunately, Ms. Susan Hilligis has died, there is in fact specific authority to continue the administration of her estate in court in the way we are doing now. As to the suggestion that there is no jurisdiction related to attorney's fees, most narrowly, I point to NRS 159.346. I gave notice of this at the last hearing where Mr. Hiligas absented himself, that is, terminated the connection to the hearing. I gave notice to this as well in my written order giving notice of this hearing. And paragraph 1 of 159.346 provides that if a guardian violates any of a protected person, any right of a protected person that is set forth in this chapter, meaning 159, a court may take any appropriate action, including without limitation. Subparagraph 2 points out that if any action by a guardian is deemed to be deliberately harmful or fraudulent, or to have been committed with malice, the court may also impose A, twice the actual damages incurred by the protected person, and B, attorney's fees and costs. So there's specific statutory authority for the imposition of attorney's fees and costs against a person situated in the position of Mr. Hilligis. I take judicial notice, of course, of the vexatious litigant designation imposed against Mr. Hilligis in this case, and all other orders imposed in this case. I am aware of the criminal proceedings lodged in the Justice Court of Reno Township against Mr. Hilligis on allegations that he kidnapped his mother. And I'm aware of the basic factual circumstances in this case because of the information provided to the court through the current guardian as well. For all of those reasons, I deny what is in essence a motion to dismiss this action for lack of jurisdiction. Mr. Torvinen, your first witness.
Roger Hillygus, please.
Mr. Hilligis, sir, would you please raise your right hand and take the oath of a witness?
Do you solemnly swear that the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Your Honor, may I have permission to treat this witness as an adverse witness?
Well, it is under the statute clear that Mr. Hilligis's position, as evidenced by the argument of Mr. Evenson on his behalf, is adverse to the position of the trust and guardianship of the estate. So he's situated as an adverse witness. He is an opposing party. Go ahead, Mr. Torvinen.
Okay. Mr. Hilligus, would you please state your full name for the record?
Roger Hillygus.
Okay, and where do you live presently, sir?
Dayton, Nevada.
Okay, did you own a parcel of residential real estate in Story County?
Your Honor, I'm going to object. I don't understand what the relevance is of that question.
Overruled. That means you can answer the question, Mr. Hilligus.
I did own a residence in Story County.
And when did you sell that? Did you sell that, sir?
I did not sell that. That was placed into a trust.
Okay, so you've received no money for that parcel of real property?
That's correct. I just received no money for that.
Okay, when was it transferred into the trust?
2016.
And what trust is it in? What's the name of the trust?
The Albert Children's Trust.
You said the Albert Children's Trust?
That's correct.
And who's the trustee of that trust?
Debbie Hiligas.
And who's the grantor? Who are the grantors, the creators of the trust?
Your Honor, again, I object on the grounds of relevance.
I overrule the objection. The financial activities of Mr. Hiligas, in particular, any activity to transfer assets out of his name and into another entity during the pendency of this motion and the pendency of his actions in this case is relevant. I overrule a relevance objection. That means you can answer the question, Mr. Hiligas.
Your Honor, if I may be allowed to make a record.
Sure.
The petition that is before the court today is for a surcharge that surcharge does not seek to hold Mr. Hilligis personally liable. In fact, the specific legal argument within that document says that the trust court has no ability to hold him personally liable for those as requested in the motion. Therefore, we had no notice that we were proceeding with my client's potential personal liability today. And on that basis, we would object.
That was the specific reason I gave notice 2 weeks ago of my intent to act under NRS 159. I took jurisdiction over the trust. I gave Mr. Hilligis specific notice that I intended to act against him, if appropriate, under 159. He has actual notice of that intent. It is an explicit notification from the court. I overruled the objection. Mr. Torvinen, your next question.
Yeah, I think the last one was who were the grantors or the creator of the trust, creators of the trust?
Mr. Hilligis?
The creators of that trust were the Albert children and their mother.
Okay, who is that? Are those the children of your wife, Debbie Hilligis?
Those are the children of my ex-wife, Debbie Hilligis. That's correct.
You got divorced from Mrs. Hilligis?
Yes.
When did you get divorced?
When we became separated and we divorced during the time I was in LA and arrested and in custody.
Do you still live with her?
No, I do not.
Okay. I'll move on from that, Your Honor. Mr. Hilligis, to your mind, as we sit on our Zoom call today, who is the trustee of the Hilligis Family Trust?
There's been quite a few different trustees. My father, I guess, was the original trustee along with my mother. It was a joint trust. I was their first choice as their successor trustee, and I've maintained that position.
So so I'm clear, and it's clear to the court. Are you saying to me that as we sit here on this Zoom hearing today, that you are currently the trustee of the Hilligis Family Trust?
Your Honor, I'm not going to allow my client to answer that question at this time.
On what legal basis? I'm so sorry. On what legal basis?
Without consulting with me first. The record clearly establishes who the person in charge of the trust is. I have no idea why this question would be relevant. And if the court directs it to be relevant, I'm asking for an opportunity to consult with my client.
I find it to be relevant in as much as your client is alleged to and may have taken acts in direct contravention of the court orders and the legal status in this case. What I mean by that more particularly is Mr. Hilligis has tried to act under color of law, indicating that he purchased a verdict from a legal entity outside the traditional court system, which confirmed his status. And if he acted, for example, under that false assertion, it goes to whether or not he violated the rights of the protected person in this case, and whether or not his actions were, quote, deliberately harmful or fraudulent, end quote. So for those reasons, I find it relevant. Please go ahead and consult with your client if you'd like.
Thank you.
Your Honor, are we taking a break so we can consult?
I believe he's muted himself and he's doing it right now.
I make a finding that paternity has been established.
He was a potential future to his children.
We're here for the court's order to show cause. Okay, so that takes care of one motion.
Maybe somebody can tell me what the status is.
Any preliminary issues we need to take care of?
We'll make sure that she's put on house arrest. As you know, the Supreme Court has
Your Honor, I've returned. I don't mean to interrupt.
Thank you. The record will simply reflect that at his request, Mr. Evenson has had an opportunity to confer with his client, Mr. Hilligis. There was an answer to the question tendered, but Mr. Torvinen, your question.
I'd just like to clean up the record, if I may, Your Honor. Mr. Hilligis, is it your assertion as we sit here today that you are the current trustee of the Hilligis Family Trust?
Your Honor, the basis for this question appears to be related to matters under which my client may be facing criminal prosecution or which could be used in a criminal prosecution against him. On that basis, I'm invoking my client's Fifth Amendment right.
Well, it is his right. Hang on. Let's talk about process. The Fifth Amendment privilege is Mr. Hilligis's right, and he must invoke it in response to each individual question to which he intends to invoke such a right. Mr. Torvinen, if you intend to ask the question, I'll give Mr. Hilligis an opportunity to respond. If he invokes his privilege, the next question will be tendered and so on. Does that make sense?
Yep.
Go ahead, Mr. Torvinen.
Okay, so to make the record clean, Mr. Hilligis, as we sit here now, do you assert that you are the trustee of the Hilligis Family Trust?
On the advice of counsel, I invoke my Fifth Amendment right of self-incrimination.
Mr. Torvinen.
Mr. Hilligis, isn't it true and a fact that on October 7, 2020, you filed a pleading in this case, the Hilligis Family Trust case, pleading entitled Request for Judicial Notice Related Cases. And on the top of that pleading, you referred to yourself as the trustee. Is that true?
The advice of counsel, I invoke my Fifth Amendment right to incriminate myself.
I take judicial notice of the filing. Your next question, Mr.
Okay.
Torvinen.
Similarly, on October 7, 2020, you filed in this case, the Hilligis Family Trust, a demand for fee waiver and a demand for a jury, wherein you refer to yourself on the top of the pleading as, quote, trustee.
On the advice of counsel, I invoke my Fifth Amendment to not incriminate myself.
I take judicial notice of the filing. Mr. Torvinen.
And Mr. Hilligis, again, is it true and a fact that on October 7, 2020, you filed a pleading titled jury demand, and on the top of that pleading, you refer to yourself as trustee?
On the advice of counsel, I invoke my Fifth Amendment to not incriminate myself.
Likewise, I take judicial notice of the filing referenced. Mr. Torvinen.
Okay, Mr. Hilligis, isn't it true and a fact that you obtained what purported to be a guardianship paper from an outfit in Arizona called We the People, indicating you were the guardian of the person in the estate of Susan Hilligis?
On the advice of counsel, I invoke my Fifth Amendment right.
Okay. And isn't it true and a fact, sir, that you presented that document to Stone Valley when you, without color of law, took your mother out of that facility in or around August of 2019?
On the advice of counsel, I invoke my Fifth Amendment right.
Okay. Now, Mr. Hilligis, isn't it true and a fact that in the trust case and in the guardianship case too, you filed multiple pleadings to either dismiss the jurist, disqualify the jurist, transfer the case somewhere else, or dismiss the case or cases? Isn't that true and a fact?
Mr. Torvinen, Mr. Evenson has not lodged an objection, but
okay,
what is the relevance of that question?
Well, the relevance is this, Your Honor. Part of at least the common law, and I didn't make an opening argument, but is that somebody conducted themselves in bad faith. And Mr. Evenson, I will just put this on the record if you'll allow me. Mr. Evenson raises a point about those cases in California dealing with specific events where you had a misbehaving beneficiary. Well, in this case, you had a misbehaving beneficiary throughout almost 8 years of litigation, and that's what this is about. Bad faith.
I'm so sorry for interrupting. What I'm trying to do is guide us as best I can in the limited time we have this morning to central facts. I've already acknowledged, and there are a series of facts in this case, in Judge Doherty's finding that Mr. Hilligis is a vexatious litigant. I am aware of those facts. I intend to use those facts if they're relevant in any findings I make. I might suggest that asking Mr. Hilligis about the machinations, my word, no one else's, undertaken in this case, given the vexatious litigant findings that have occurred in this case, is of less usefulness. I'll allow you to ask the question. Do you remember
Your
the
Honor,
question?
I will seek guidance from you. And this is the additional basis for relevancy. As I read NRS 163.115 sub 4, what the statute says that is that if a trustee, a beneficiary, some other interested person files a petition or otherwise moves to remove a trustee, if a court finds that that is done to harass or in bad faith, and I'm paraphrasing that, I can read the statute to you under sub 4. But if the court finds if it's done actually the exact quote is not done in good faith, that's what the statute says, then the court may award attorney's fees against that person or otherwise surcharge them for that particular event. It doesn't use the word surcharge, and Mr. Evenson's right about that. But what we had in this case, and I got thinking about this last night, and I won't go down this rabbit hole if you've instruct me not to, because I don't want to waste the court's time either. But what you have is a repeated actions in terms of a pattern to not just, and there is one motion, or you could deem them two petitions that Mr. Hilligis filed to remove the fiduciaries in one capacity or another. But what there was a refusal to recognize that the court even had jurisdiction to do what it did in the first place. Almost. And so that's where I'm headed with this, Your Honor. I don't want to waste your time.
I appreciate, hang on. I apologize for interrupting.
That's okay. I'm sorry.
It's all right. Hear me out, please.
I will.
So Chapter 163 and Chapter 164, broadly and generally, deal with administration of trusts and issues related to trusts. And in this case, it is clear throughout the history of the trust case and the guardianship case that Judge Doherty exercised jurisdiction over the trust assets because they are, in fact, as a term of a description, a part of the estate of Susan Hiligas. The trust remained and was formulated as constituted by the Hilligis family. Various issues happened in the trust. But when I gave notice 2 weeks ago that I intended to act under 159, it was intentional. 159, enacted now 3 legislative sessions ago, came about as a result of what I call the Investigative Guardianship Commission. It was a commission invested by then Chief Justice Hardesty. He was now the Chief Justice again, and resulted in a very large piece of legislation, that both enacted Chapter 159A related to minor guardianships and reworked and retooled Chapter 159. Chapter 159 has robust and explicit remedies in circumstances such as this. So, for example, Chapter 159 codifies the Bill of Rights for a protected person, i.e. Susan Hiligas, in a case such as this. And I made clear 2 weeks ago, and I remind you today, I intend to act under Chapter 159, Mr. Torvinen. I know your motion is in the trust case, styled pursuant to Chapter 164. You said 164, 115. In fact, I don't find a 164, 115.
Yeah, that's an error. Sorry about that. It's 163, 115.
All right, thank you. And I acknowledge that 163 provides some guidance and remedies related to what you've called a surcharge, although that's not the language of the title. But remember, when we met 2 weeks ago, I asked you to acknowledge as an officer of the court that there is, in fact, no explicit remedy under Chapter 163 or Chapter 164 authorizing a surcharge in the way in which you seek to apply it in this case. And as an officer of the court, as I expected you to do, you acknowledged that's true. And it was at that juncture that I took explicit and specific jurisdiction over the corpus of the trust into the guardianship estate item, if you will, and gave notice of how I intended to act in this case. Now, 163.115.4 reads explicitly, if the court determines that a proceeding instituted pursuant to subsection 1 by a settlor, co-trustee, or beneficiary against a trustee was not instituted in good faith and based on probable cause, the court may order that the settlor, co-trustee, or beneficiary who is maintaining the proceeding against a trustee pay all or part of the costs of the proceeding, including, without limitation, reasonable attorney's fees. That does, in fact, support the relief that you're requesting. But to reiterate, and the purpose for my interruption is the remedies, if any, Mr. Torvinen, I intend to fashion, will be pursuant to Chapter 159. They are more plenary and more explicit and clearer, candidly, in their language than any other language in Chapter 163 or 164.
I appreciate the direction, Your Honor. Thank you very much.
You're welcome. Please proceed.
Okay. Mr. Hilligis, I want to take you back to the autumn of 2015. Were you the trustee then?
Can you be a little more specific with your question as far as the date?
Okay. Prior to December 22, 2015, were you the trustee of the Hilligis Family Trust?
Your Honor, to the extent of this, I think my client, for a variety of reasons, which are obvious, wants to make sure that he's answering questions correctly. I believe that that question should be in the records of the court, and we would defer to that answer as being correct. I don't want this to be a memory game with my client or that kind of thing. And that's the only reason I'm speaking. Sorry.
I understand your concern and share your concern, Mr. Evenson, for your client's Fifth Amendment privilege. And I believe Mr. Torvinen is doing nothing wrong, but he is sort of bouncing on topics and dates. Let the record be clear, this is not a memory test. I can, to some degree, take judicial notice of when Mr. Hiligas was and was not the trustee according to court documents. With all of that said, go ahead, Mr. Torvinen.
Okay, I'll make it. I'm not here to run a memory test either, Your Honor. Mr. Hiligas, during the time that you served as trustee of the Hilligis Family Trust, did you liquidate a substantial amount of assets then held in Peterson Management to pay off the mortgage of the Nob Hill residence, your folks' residence, at that time?
Your Honor, I'm going to advise my client to invoke his Fifth Amendment privilege should he choose to do so on that issue.
Mr. Hilligis?
On the advice of counsel, I invoke my Fifth Amendment.
Thank you. Your next question, Mr. Torvinen.
Okay, Mr. Hilligis, is it true and a fact that the Hilligis Family Trust incurred an additional $25,000 of capital gain tax that had to be paid for the 2015 tax year?
Your Honor, I believe that is already contained in the records of the court.
Are you willing to stipulate it?
Are you willing to stipulate
that it
I'll
is
withdraw
true?
my objection. My client can answer the question. Sorry. Go ahead, Roger.
I do not have any information with respect to that. I've not seen anything. Sorry, I can't answer that.
Fair enough. Okay. Now, Mr. Hilligis, you were removed as trustee of the Hilligis Family Trust, were you not?
Your Honor, I believe on behalf of my client, if I may, I think he would defer to the record of the court. That took place. I'm concerned about answering those questions for a variety of reasons.
Mr. Hilligis, do you have a response?
What was the question again?
Yeah, we're sometime in late 2015, were you removed as the trustee of the Hilligis Family Trust by the court?
There were a number of proceedings. I can't remember exactly what happened on those dates.
Well, I'll be more generic. At some point along the way, were you removed as trustee of the Hilligis Family Trust by the court?
On the advice of counsel, I invoke my Fifth Amendment.
Okay.
Mr. Torvinen?
Were you removed as guardian, of the person and the estate of Susan Hilligis by the court?
Your Honor, may I have a moment to consult with my client briefly?
Sure, go ahead.
Thank you. Your Honor, I've covered these types of questions with my client in regard to his hesitation and those kind of things, and I think we're prepared to proceed in a more productive manner. So if through you, Your Honor, if Mr. Torvinen would re-ask the question, I think we can get an answer on it.
All right, thank you. Mr. Torvinen?
Mr. Hilligis, did the court remove you at some point as guardian of the person and the estate of your mother, Susan Hilligis?
It's my understanding that there is substantial court record regarding that, and I believe that did happen.
And, sir, isn't it true in a fact that in the hearing to remove you as guardian and trustee, which occurred in or about December of 2015, you informed the court that you didn't believe you were bound by the orders of the court Isn't that true?
I don't remember that, but if that happened, I'm sure it's in the court record.
Well, as we sit here today, do you believe that you're bound by orders of this court?
Courts issue orders and those are to be followed.
In a general sense, do you believe you followed the orders of the court prior to today?
Your Honor, I would object to the form of the question. My client's belief as to whether or not he's followed the court orders would be.
I sustain your objection. Mr. Torvinen, please rephrase.
I'll move on. Mr. Hilligis, did you object to your mother being placed in Stone Valley Memory Care Center?
On the advice of counsel, I invoke my Fifth Amendment right.
Mr. Torvinen.
Mr. Hilligis, did you object to the sale of your folks' Nob Hill marital residence?
On the advice of counsel, I invoke my Fifth Amendment.
Mr. Torvinen.
Mr. Hilligis, isn't it true that Judge Doherty, the previous jurist in this matter, allowed you to continue to reside with your wife at the Nob Hill residence, even when Susan Hilligis was no longer a resident there?
I cannot remember exactly what happened with respect to Judge Doherty and what she was thinking and if that was true or not.
So the answer is he doesn't remember. Your next question, Mr. Torvinen.
Isn't it true in fact that you physically and by way of signage prevented the trustee at that time, Casey Zusman, from doing an inventory of personal property and inspecting the residence, the Nob Hill residence? Isn't that true?
I cannot tell you if that's true or not. There was a lot going on and I don't remember.
Well, do you remember being served with an eviction order by the Justice Court of this county to remove yourself from the Nob Hill residence in or about, if I recall correctly, September of 17, maybe September 16. You remember that?
I don't remember if I've seen that order or not.
So as you sit here today, you say you had your no knowledge or no recollection of being evicted from that residence.
I know that I left that residence at some time, but I don't remember the exact circumstances.
Do you recall, sir, referring to the Nob Hill residence several times in the pleadings as, quote, your property or your house? Do you remember saying that?
Your Honor, I have to object to these questions. Again, they are matters that would clearly be in the record of the court. The court can take judicial knowledge of whatever statements was made in them. And I don't see the point in asking my client these questions with the limited amount of time we have.
Well, in a traditionally aligned and procedurally traditional case, if there is such a thing, the declarant, in this case, the person giving testimony, Mr. Hiligas, would not be under the cloud of a criminal allegation of a Category A felony, Mr. Torvinen. Mr. Hiligas is, of course, subject to very serious allegations, criminal allegations. He is in substantial jeopardy for statements he makes under oath. This record is available to the state and to the defense in any criminal case against him. I would suggest I have concerns about the limits of his Fifth Amendment protections. I am obligated to remind him of those. Thankfully, he's hired Mr. Evenson, and Mr. Evenson has reminded him of those. And Mr. Evenson is assiduously protecting his client's rights, which must occur. I might suggest, Mr. Torvinen, to the extent that having Mr. Hilligis invoke his fifth has occurred repeatedly, the point has been made, if there is a point.
All right.
In other words, I can and will draw negative inferences against him by his invocation of the Fifth Amendment, as I'm allowed to do in civil cases where there is, as it were, tracks at the same time. And I make negative inferences against Mr. Hilligis by his invocations already. Going forward, I don't know what, I ask you to exercise discretion, I guess.
Okay, Your Honor, I apologize. It's very challenging and I apologize to the court.
No apologies necessary. I'm just offering some guidance in light of the objection.
Okay. Mr. Hiligas, I'm going to move on. When this Donnybrook, for lack of a better way to describe it, started in 2014, to the best of your recollection, what assets were in the Hilligis Family Trust?
I'm sorry, could you repeat the question? I did not catch the word that you used at the beginning.
I used the word Donnybrook. That's when this matter started in litigation in, I believe it was January 14. To your knowledge, what assets were in the Hilligis Family Trust?
I still missed the word. Could you define the word? I'm not sure of that word. I've never heard that word before.
Well, he changed the question, Mr. Hilligis. He said when this lawsuit or controversy began, when the issues related to the trust began. Do you understand the question in that context?
Okay.
Should I proceed, Your Honor?
Yes.
What assets, to your knowledge, were in the Hilligis Family Trust?
There were investments, there were properties and vehicles. I think just the standard assets that I remember.
Well, there was a Nob Hill residence, right?
That was the family residence. That's correct.
That was in the trust, right?
Yes, it was.
And there was a Peterson Wealth Management account, correct?
Peterson Management was the investment advisor for my parents, and they did have investments at that investment brokerage house.
And isn't it true in fact that was near $400,000 in that account?
I do not recollect what was in the account back in 2014, but there was investments in those accounts.
Would you agree with the account had a substantial amount of money in it?
There was money in those accounts. I don't remember what was substantial or how much, but there was money in an investment account with Peterson Wealth.
And isn't it true in fact that your mother and your father, I think, both had IRA accounts at that point? Isn't that true?
I believe they did have IRA accounts. I don't remember specifically if they both did, but I know that there was an IRA account.
Do you recall how much was in that account?
I don't recall exactly. I don't believe there was a lot in there, but there was an IRA account is my recollection.
Did you hear what I informed the court of at the beginning of this matter about how much is left after payment of fees?
There was some discussion at the beginning of numbers, and I didn't catch the exact numbers, but you can refresh my memory.
Okay, well, I don't have the exact number in front of me, but does after the payment of fees in this matter, there would be the sum of about $163,000 left. That sound familiar?
That sounds like a number that was discussed earlier.
You would admit, would you not, sir, that that's substantially less than was in this trust at the beginning of the litigation in this matter?
On the advice of counsel, I invoke my Fifth Amendment.
Mr. Torvinen?
Okay. Mr. Hiligas, I want to take you back to December of 2013. I know it's a long time ago. Do you remember getting a order for temporary protection against domestic violence against your sister, Robin Renwick, who's seated to my left here?
Your Honor, I'm going to object on the grounds of relevance.
How is this relevant, Mr. Torvinen?
Well, Your Honor, it goes to two things. It goes to, well, really one thing. It goes to the bad faith conduct from the beginning in this matter. And it goes to an agreement that I thought was reached back then that would have stopped all of this stuff. Again, that goes to bad faith.
I'll give you some latitude. I overrule the objection. That means you can answer the question, Mr. Hilligis. The question again, please, Mr. Torvinen.
Your Honor, before I'm sorry, Your Honor, and please forgive me, but may I make a record relative to that issue?
Certainly.
Thank you. Your Honor, a TPO is obtained by an ex parte factor from a justice court, or in some places a municipal court, I guess, relative, or a district court, relative to allegations involving various acts that may or may not have taken place. The fact that they're granted or not granted, or that they're even sought, is something that should not be chilled by allowing questions later to be used with regard to motive to lie or anything else. Now, the contents of those documents, I believe, could be used because they're sworn statements and everything else. But the mere fact that they exist or they were sought is the basis for my objection in this case. I just want to state that for the record. Thank you for the opportunity.
Yeah, I'm going to move on, Your Honor, from this. That's just a foundational question. Mr. Hiligas, if it's okay, I'll ask it again. Did you obtain an order for protection against domestic violence, temporary order, against your sister, Robin Renwick, in late 2013?
There was a TPO that was filed.
And do you recall you attending an objection hearing to that TPO with your sister sometime in early January of 2014?
It's my recollection that there was no hearing with respect to that.
Okay. Do you recall reaching an agreement with your sister at that point, whether it was not a hearing, for the appointment of an independent trustee, neither you nor her, an independent trustee of the Hilligis Family Trust? You remember that?
Your Honor, I'm going to object to this question. It may go into settlement discussions between parties in a contested matter that would be inadmissible under statute.
Mr. Torvinen?
Well, it's not admissible if you read the statute closely. Was it 50230 or 50.050? If you read the statute closely, it says you can't explore that stuff to the extent you're trying to prove there's an agreement, but you can explore it for any other matter, including bad faith or pattern or anything else.
Hang on, Mr. Torvinen. You just cited, was it NRS Chapter 50 you're referring to?
Maybe it's 48.050, 49.05, something 050. Right there in the beginning of the evidentiary code.
Well, if I look at NRS Chapter 48, this is a relatively arcane area of the law. NRS Chapter 48 refers to admissibility. There is no 48.050. There's 055. It's methods of proving character.
Well, I can bring it up. I'm sorry if I misquoted.
I think we need to, because
Your Honor, I believe it's NRS 48.105, offers to compromise.
Yeah, that's it. Sorry.
And it's subsection, thank you, Mr. Torvinen. In subsection 2, it says, this section does not require exclusion when the evidence is offered for another purpose, such as bias or prejudice, negativing, that's an interesting word, a contention of undue delay, or proving an effort to obstruct a criminal investigation or prosecution. I think it's a very tough road to go down in this case under these issues.
Yeah, so subparagraph 2, thank you for that, Mr. Evenson, provides this section does not require exclusion when the evidence is offered for another purpose, such as proving bias or prejudice of a witness, negativing a contention of undue delay, or proving an effort to obstruct a criminal investigation or prosecution. So which of those buckets do you think this fits into, Mr.
Your Honor, it doesn't fit in any of those buckets, but it says another purpose. It's the statute is not written in an exclusionary fashion. It's written in an inclusionary fashion. And that would be my response. It's inclusion, not exclusion.
Well, I offer this observation, having taken judicial notice, for example, of the order identifying Mr. Hilligis as a vexatious litigant, which makes reference to the TPO, among other facts in the case. For example, I offer a clear understanding that there are convoluted and difficult family dynamics between Mr. Hilligis and his sister. It is clear and evident in the record at many junctures that they have disagreed about the management of their parents, plural, estate and their parents' guardianships needs while each of their parents was still living. I am aware that either of the parties has had multiple opportunities to stop the bleeding, in this case, of professional fees and attorney's fees. Given that observation, I wonder at the necessity of this line of inquiry, Mr.
I'll move on, Your Honor.
Thank you.
Let me gather my thoughts for a moment.
Sure.
Oh, Mr. Hilligis. If I recall correctly, your father, Gene, died in 2015, in August of 2015 or thereabouts. Is that correct?
My father did die in August of 2015, as I recall.
And isn't it true in fact that you accused your sister, the other beneficiary, Robin Renwick, of hastening his death by neglecting his care and placing him where she placed him? Isn't it true in fact that you accused her of hastening his death?
I believe there were contributing factors, that he was not properly cared for by his guardian. And if that did result in his death, then that remains to be proven. But those were my beliefs at the time based on medical records.
Well, do you believe that your conduct in this case hastened your mother's death?
Invoke. Upon the advice of counsel, I invoke my Fifth Amendment.
Mr. Hilligis, when you were removed in 2015 as trustee, do you recall going down to Plumas Bank after you were removed as trustee and taking the sum of $15,000 out of the Plumas Bank account under the guise of trustee?
Invoke. On the advice of counsel, I invoke my Fifth Amendment.
Isn't it true in fact, sir, that when your mother was placed, that's Susan Hilligis, in Stone Valley Residential Memory Care, that over the course of the next, I think it's about 3 years, you visited her just a handful of times, less than 5. Isn't that true?
On the advice of counsel, I invoke my Fifth Amendment right.
Mr. Hilligis, isn't it true and a fact that during the time that the purchase agreement to sell the Nob Hill residence was being negotiated, that you threatened the real estate agent for the buyers and the real estate broker for the buyers?
On the advice of counsel, I invoke my Fifth Amendment.
Mr. Hilligis, did you read the petition to surcharge that was filed in this matter a few months ago by my client, Robin Renwick and the trustee Kelly Lund. Did you read it?
Your Honor, I'm going to object on the grounds of relevance.
It's relevant.
I overrule that objection. That means you can answer the question, Mr. Hilligis. Mr. Torvinen?
Yeah, did you read that petition, Mr. Hilligis?
I have reviewed that.
And did you read the accounting for the trustee of the trust? It's only a one-pager.
I've reviewed it.
Do you recall that there's a line item at the bottom of the accounting and it's mentioned in the petition indicating there's a holdback of $15,000 by the trustee to indemnify the buyers of Nob Hill? Do you remember reading that?
I don't recall that.
Okay. Mr. Hilligis, how many appeals have you done to the Nevada Supreme Court in this case and in the guardianship case?
I don't know the exact number, but I do know that I've done some appeals to the Nevada Supreme Court.
And in one you filed a brief, did you not?
I believe I filed a brief. That's correct.
And isn't it true in fact that in that brief you filed, you didn't cite the record one place?
I cannot speak to that.
Okay. That appeal was dismissed by the Nevada Supreme Court, wasn't it? Or the appeals court, I think. Wasn't it dismissed?
I believe that it was dismissed.
And then you filed in U.S. District Court, did you not?
Can you be more specific?
Well, you filed a complaint on behalf of your mother. Remember, it's a 100-page complaint in U.S. District Court, alleging that her constitutional rights had been violated, in essence. You remember that complaint?
On the advice of counsel, I invoke my Fifth Amendment.
Did you sue me personally with that complaint?
On the advice of counsel, I invoke my Fifth Amendment.
Did you sue your sister personally?
On the advice of counsel, I invoke my Fifth Amendment.
Did you sue the previous jurist? That's the Honorable Judge Francis Doherty personally.
On the advice of counsel, I invoke my Fifth Amendment.
Okay. Nevertheless, that complaint was dismissed by the United States District Court here in Reno, correct?
On the advice of counsel, I invoke my Fifth Amendment.
Okay. Did you appeal that to the Ninth Circuit Court of Appeals, Federal Court of Appeals?
On the advice of counsel, I invoke my Fifth Amendment.
Okay. Did you remove your mother from Stone Valley Memory Care Center in August of 2019?
Your Honor, not only do I object to that question, but it's very clear from this court's previous rulings.
Hang on. I don't need a speaking objection. If I understand your objection, it is relevance, and you will instruct your client to invoke his fifth. Mr. Torvinen, what's the purpose of the question?
Well, you focused me on those guardianship statutes, and they're focused on harm, whether financial or personal, to the ward. And that question's directly aimed at that. And
I understand that it is. I'm going to overrule the objection, but of course, Mr. Hiligas is going to invoke. Mr. Hiligas, I assume you would like to invoke your privilege against self-incrimination in as much as this goes to a central fact of the criminal charges against you. Is that correct?
That's correct, Your Honor.
Thank you. I will honor that. Your next question, Mr. Torvinen.
Okay. The court mentioned this. Mr. Hiligas, you have not filed at least one accounting that was due in this matter. Isn't that correct?
On the advice of counsel, I invoke my Fifth Amendment.
Your Honor, may I make a record here? I mean, I can hear Mr. Evenson in his client's ear every time, and that's highly unusual. Now, I understand there's Fifth Amendment
Actually,
issues here, but wow.
So sorry, Mr. Torvinen. I apologize for interrupting.
That's
this is
okay.
an area about which you might not have experience, Mr. Torvinen.
I do not.
But if we were in court, I would allow Mr. Evenson to sit next to Mr. Hilligis at the witness stand and advise him on a question by question basis about his
And I
rights.
withdraw that. I completely withdraw it.
All right, go ahead.
Mr. Hilligis, is it true and a fact that during the time you were the trustee of the Hilligis Family Trust, you took a trust asset, namely a utility trailer, and placed it in your own personal name on title?
On the advice of counsel, I invoke my Fifth Amendment right.
Isn't it true and a fact, sir, that there's a Kubota tractor missing from the trust?
On the advice of counsel, I invoke my Fifth Amendment right.
Isn't it true and a fact? There's an antique wagon missing from the trust or trust assets.
On the advice of counsel, I invoke my Fifth Amendment.
As we sit in court here today, sir, are you seeking half of what's left here?
Your Honor, I believe that question is beyond the scope of this hearing.
That's precisely what this hearing's about.
Well, I'm going to give Mr. Torvinen some latitude. It is relevant to know your client's position about what remains. You were careful, I noted, Mr. Evenson, in your opening statement, not to explicitly say anything other than you objected to the distribution sought. In sum, I understand the distribution sought to be to give all of the remainder over to the trust and or Ms. Renwick, as the case may be. I'll give you some latitude, Mr. Torvinen. I find it to be relevant, so I overruled the objection for that reason. Go ahead, Mr. Torvinen.
Mr. Hiligas, I'll state it again. As we sit here today, are you seeking half of what's left of the trust assets?
Your Honor, it's one of those situations where if I'm close enough to the line, I'm going to err on the side of caution and advise my client to invoke.
Mr. Hilligis, you have to explicitly verbalize it. Do you intend to invoke your Fifth Amendment privilege, sir?
On the advice of counsel, I invoke my Fifth Amendment, Your Honor. That's correct.
Thank you. Mr. Torvinen.
Okay. Sir, are you objecting to the payment of my attorney's fees?
You can answer that.
I do object to the payment of your attorney's fees.
Okay. Looping back around to another matter, isn't it true and a fact that this house that we discussed early in your testimony in Story County was transferred to your wife as trustee on January 22, 2020?
Your Honor, it was my understanding that the court allowed these questions relative to my client, perhaps since this motion was filed, hiding personal assets through something. If that was done on January 22nd of 2020, that would be long before any motion in this case was filed, and I would ask the court to reconsider my objection.
I have considered your objection. I overrule it. For example, in the order designating Mr. Hiligas a vexatious litigant, Judge Doherty went into great detail describing actions that had occurred from 2014 forward. Judge Doherty gave notice of the intention to impose attorney's fees pursuant to 159.0486 at that time, and Mr. Hiligas has been on notice during the entire course of this litigation of the court's position that it will shift the burden of his vexatious conduct and any conduct which waste in the term of art, in the definition of the term of art of that word, that wasted his mother's estate. And so for all of those reasons, I find the question to be relevant. Mr. Torvinen, please go ahead and proceed. Please ask it again.
I will.
I wouldn't remember if I were Mr. Hilligis what the question was.
Sir, isn't it true and a fact that by deed, recorded January 22, 2020, you transferred the house out at Mustang in Story County to your wife as trustee of this Albert Children Living Trust.
On the advice of counsel, I invoke my Fifth Amendment.
Mr. Hiligas, isn't it true in fact that when you were trustee of the Hiligas Family Trust, you paid Woodburn Wedge about between $20,000 and $21,000 without court approval?
Your Honor, I'm sorry. I'm going to advise my client to invoke on that question.
Mr. Hilligis?
On the advice of counsel, I invoke my Fifth Amendment.
Thank you.
No further questions, Your Honor.
Thank you. Folks, we're going to take a 10-minute recess. We'll be in recess until approximately 10:46. And so please go ahead and just turn your devices off during this period of recess. I'll come back on the record at about 10:46.
Thank you, Your Honor.